Welcome to our first installment of Parker Poe Rapid Response. I'm Matt Wolfe, a healthcare and public policy attorney here in Raleigh, North Carolina. And today I'm joined by my colleagues, Robb Leandro here in our Raleigh office and Brad Overcash in our Charlotte office. We all advise long-term care facilities like nursing homes on legal, regulatory, and risk management issues. Today we are going to talk about the final rule issued by the Centers for Medicare and Medicaid Services that will be published on October 4th, 2016. The New York Times recently published an article concerning the arbitration agreements of the CMS final rule. Rob, first to you, a couple simple, quick questions. What are arbitration agreements, and what is their role in the nursing home context?
Well, arbitration agreements are binding contracts that are entered into by individuals, private parties. In fact, they're favored by the state in a lot of contexts. But essentially what they say is if there are disputes between two parties, you're going to not go before a court of law, but you're going to present your case in front of a neutral arbiter, and that decision would be binding and not appealable. The advantage to that is that in often cases it's quicker, certainly quicker. There's less discovery or legal cost involved. You don't have to worry about bearing the cost of an appeal. Other things that are important about it is that usually it's going to be a much cheaper way to litigate a case. And so you can understand a lot of private businesses favor those types of agreements, and certainly nursing homes do as well.
And so they take those cases out of the judicial system. Brad, to you, why are arbitration agreements specifically important for nursing homes and their disputes with residents?
Well, Matt, I appreciate that. This is such an important topic. Thanks for hosting us today. I would say that nursing homes and residents, for that matter, have long appreciated the opportunity to engage in arbitration. It provides a private setting for disputes to be resolved rather than in the public court system. And that privacy is important in so many of these cases where very sensitive information is involved, perhaps injuries that families just don't want out there in the public sphere. I think that's one of the reasons. It also tends to cut the cost both for the facility and for the resident. So there's a reason the state of North Carolina and the federal courts have deemed that arbitration is in the best public policy interest and should be encouraged. I know that's changing thanks to this rule, but they've been favored for a long time.
Thanks, Brad. So, Rob, back to you. What is the impact of this CMS final rule that's 800 pages long and deals with a lot of issues? What is its specific impact on arbitration agreements in nursing homes?
Yeah, glad you mentioned that, Matt. As much as we're going to focus today on the arbitration agreement, if you are a skilled nursing facility, certainly the release of this final rule is going to have an impact on lots of parts of your service model, and we'd encourage all of our clients to check that out. But in terms of the arbitration agreement, I think that the impact is going to be important. And the changes, which are, Brad discussed what arbitration agreements are, is now, typically as an arbitration agreement, you're going to have the parties enter into it upon admission. One of the things that the CMS was concerned about is these agreements that would be conditioned on admission, meaning we're not going to admit you unless you are willing to sign this arbitration agreement. As a practical matter in North Carolina especially, I think those types of agreements have sort of been disfavored. So what we see largely are arbitration agreements which are very clear on their face, not subject to a condition of admission. So they can sign them or not at the time of admission, and certainly they would admit people usually. What this agreement, what this new rule says, importantly, is that those types of arbitration agreements are no longer going to be valid if you accept Medicare or Medicaid funding. Not just for the patient, but the facility itself. So it's important to know it's not determined by whether the patient or not receives Medicaid or Medicaid, but whether the facility receives payments. What it does then is that it takes those arbitration agreements and moves them. You can enter into them in a different time period, and that time period is after a dispute arises. That means they're sort of called what they are calling them post-dispute arbitration agreements. Frankly, from a legal perspective, I think it's going to be very unlikely that if there is a dispute, parties are going to want to enter into arbitration agreements. So I think ultimately this means that you'll see a lot fewer arbitration agreements going forward. But the sort of pre-dispute, upon admission arbitration agreements are sort of going the way of the dinosaur, so to speak, in these facilities. They're gone. They won't exist. I would say, and I don't know if I'm getting ahead of myself, Matt, but one thing you should know is if you've been using these agreements, the rule very clearly says the ones that have been signed are still, they're not making a question about enforceability of those, nor are they automatically negated. This only applies to those agreements signed from the final rule forward and not agreements you might enter into before. Those will stand or fall based on their own legal merits, just as before.
It's important to note when you're talking about timing that there are a number of other timing provisions within the final rule that we're obviously not going to talk about today, but certainly worth looking at closely and examining as you move towards complying with the requirements under the final rule. So, Brad, with respect to essentially prohibiting going forward any pre-dispute arbitration agreements, why is this such a significant change for the nursing home industry?
It's significant because the nursing home industry has been using arbitration agreements to streamline the process of handling disputes with residents and residents' families. It's a much more efficient process, typically, and it keeps the nursing home and the resident out of the public court system, which can take 2-3 years in some cases. And now all of those are going to be decided there. So I think you're going to see a lot slower process for residents to have their disputes and disagreements resolved. I think you're going to see a lot more inefficiency from the nursing home standpoint. It's going to affect the industry significantly. As Robb said, and I completely agree, that post-dispute arbitration agreements are not likely, as a practical point, to be signed on any widespread basis. Because if you think about it, the indication of a post-dispute arbitration agreement means the parties are in an adversarial position. There's a dispute that's arisen between a resident and the nursing home. That is not a very practical time for the nursing home to then approach the resident that they're in now an adversarial position with and ask them to sign a private contract and convince that resident that it's beneficial for them. So I think it's going to significantly impact the nursing home industry and, quite frankly, will likely drive up the costs of litigation and dealing with disputes with residents.
Yeah, to echo that, I mean, I don't think CMS denies that fact. In fact, if you read the rule, I think they're anticipating that this is going to cost providers a significant amount of money potentially on future litigation cost, certainly. The other thing that's interesting is, as you mentioned, Brad, these arbitration agreements, Matt, typically have provisions which made the information and findings confidential. And part of this is a way of CMS saying we want more of this information out to the public. And that'll certainly be a result of this. So, I mean, I think providers are also going to have to consider how they manage litigation in a different way, potentially, because this information will largely be public information. The other thing is, even in a post-dispute world, the new language says if you enter a post-dispute arbitration agreement, you do have to still allow individuals who are residents to be able to report to state, local, and federal officials anything they would want. So to tell them about the issue. So you can only still, now you're going to be severely restricted on those limitations. I think before you could have more broad limitations, and that's a big change.
So it sounds like nursing homes, from both what you've said, Brad, and from what you've said, Robb, are going to be facing not only more litigation in courts brought by nursing home residents and their families, but also potentially, because of that requirement that they be able to continue to share information with governmental authorities, more regulatory activity as well as a result of this change to the arbitration agreements.
Yeah, I think it's possible. Brad?
Well, and I was going to say, Robb raises a great point about the privacy of an arbitration award. The effect of this could be to encourage settlement if privacy is important to the nursing home in a particular case. If the facts are particularly bad, if it's in the public court system, the only way to keep that result private would be to enter into a settlement agreement with a confidentiality provision, because you don't have the opportunity for a private remedy through the arbitration agreement. So it may have the effect of encouraging some settlements in certain cases.
So Brad, quickly, what tips would you offer to nursing homes in order to comply with this part of the CMS final rule?
Well, first of all, you need to understand that any arbitration agreement and an arbitration program that you've had in place that's resulted in properly executed arbitration agreements for your current residents, those stand despite this rule. So you don't have to go and fail to enforce those arbitration agreements. I think they need to immediately begin the process of stopping the arbitration offering program because they're typically offered upon admission. And I think those programs need to be halted. I think they need to consult with their legal counsel to decide whether or not to offer, and if they're going to offer it, in what fashion to offer post-dispute arbitration agreements. There's a real political and risk management calculus there that we don't have time to explore in detail on this vlog today, but I certainly think that's worth having that discussion with your risk managers and with your legal counsel on that respect.
Great points, Brad. It sounds like some tough conversations. Rob, final question to you. We did promise to make this rapid response rapid.
Right.
What does the CMS final rule for nursing homes foreshadow for arbitration agreements involving other healthcare providers?
I mean, I think they specifically say they're going to be looking into how this affects healthcare, what the effects are, and if they're overall positive. I think we can see this being a trend for all Medicare and Medicaid providers out there, and I wouldn't be surprised after the data comes out 1 or 2 or 3 years into the program that this doesn't spread.
Thank you for tuning in to this first installment of Parker Poe Rapid Response. Really appreciate Rob and Brad joining us today. If you have more questions about the CMS final rule, please feel free to reach out and contact Brad, Rob, or myself. Our contact information is available on our website, www.parkerpoe.com. And for a more detailed analysis of the CMS final rule and other cutting-edge health law topics, please check out our blog at healthlaw.parkerpoe.com. Thank you very much.